If Amazon has suspended your account and is now holding your money, then this video is for you. Hi, my name is Mario Simonian, and I'm the founding attorney here at ESCO. And before starting this law firm, I built and sold two Amazon brands, two seven-figure Amazon brands. But now we help out sellers just like you. So we've helped clients recover millions from Amazon. And the number one question that they always ask whenever they come to us is, how can Amazon be holding my money? It belongs to me. And our answer is the BSA, the Business Solutions Agreement, in Section 2 states the grounds or the reasons why Amazon can hold your money. And all of this really comes down to reducing their risk. So Amazon, if they're unable to identify who you are, if they're unable to identify who your business is, then they could go ahead and hold your money because their reasoning is, we don't know who owns this account. We've been unable to KYC, know your client audits, unable to perform that, so we can't release the funds. Next thing is if you've breached their agreement or any other policies, whether it's IP infringement, whether it's drop shipping, or whether it's your performance metrics decreasing, they want to protect themselves and hold on to your money. Next is if they've got some sort of court order that states that they need to hold that money, freeze that money, then they're going to go ahead and comply. So those are the reasons why Amazon could hold your money. But 99% of the time, it comes back to your account is suspended. And Section 3 of the BSA states that they can really suspend you for any reason as long as it's to protect their own interests or protect their customers. But just know that they can hold your money. But the good news is you do have rights, and that's what we're going to be talking about next. Since most of the time Amazon is holding your funds because of a suspended account, what you should look into first is, can I get this account reinstated? So I would say explore the reinstatement options, because if you can get the account reinstated, then it's guaranteed that the funds will be released. So go through the POAs, the plan of actions, any appeals you could do internally. Don't forget about the disbursement appeals email address. Get an email out to them. And if the internal appeals path doesn't work, also consider external appeals such as the BBB and the AG, whether it's your state AG or the Washington State AG, since that's where Amazon is based. But again, about 99% of the time, whenever we encounter funds being held, it's usually linked to an account suspension. So if you could get that account reinstated, then your funds will be released. So look into that as a first option. If you see that that doesn't work, I also always recommend that our clients talk to their CPA or their tax strategist to see if there's a way or if there's any benefit in writing that loss off as a business loss, just to save on some taxes. But if those don't work, or if you want to get more aggressive, then we've got pre-arbitration as an option and also arbitration. But before you consider arbitration, which is really the nuclear route, that should be considered last option, I want you guys to always talk to a professional or a law firm specializing in Amazon law about pre-arbitration, or what we call synthetic arbitration. Now, with synthetic arbitration, this is a precursor to arbitration. What we want to do is notify Amazon's attorneys, the same attorneys that will be helping Amazon and representing Amazon in arbitration. We want to notify them of this case, make sure they know all of our grounds, what our arguments are, and what we expect or demand from them. We want to make sure they're aware of all of that and give them an opportunity to fix or resolve this before we head to arbitration. So I'm a big fan of going that route before we even look at arbitration. I'm actually don't want to call it pre-arbitration, let's call it synthetic arbitration. So before you look at arbitration as a solution, I always want you guys to talk to us about synthetic arbitration. This will give Amazon's attorneys, this is the same attorneys that will be representing Amazon if we do go to arbitration, giving them a chance to take a look at our case so they know what our grounds are, what our facts are, and what our demands are, and give them opportunity to fix this, to resolve this issue before they, Amazon, and us have to take that step and go to arbitration. So I'm a big fan of using synthetic arbitration before arbitration. And it also, even if they're going to reject our demands, it gives us an opportunity to see what their arguments are going to be and what their position is. And that's why synthetic arbitration big fan of before we look at arbitration. Now, if we do have to go to arbitration, then we want the damages to be $150,000 or more. What does that mean? So the funds being held or any inventory that Amazon is holding at FBA, those two together should equal 150 or more. And there's a reason behind it. The reason behind it is we want to make sure there's enough damages so it's worth your investment and also our investment in time, just so we know you've got a good opportunity to get some funds really back. We want to make sure it's $150,000 or more. Now, in arbitration, know that 90% or more of cases settle and they don't go all the way. And this is true in arbitration with Amazon. It's also true in real world with litigation. Most cases settle and never reach the end where a judge has to make a decision or an arbitrator has to make a decision. And Amazon's tone really changes in arbitration once we've got them in AAA arbitration. And if we were to sum up our argument in one sort of sentence, is that the harm that you, the seller, have caused to Amazon, it doesn't equal the funds being held. So the question being asked once we're there is, Amazon, what did our client do? For example, they breached this policy or they're a risk to our platform. Fine. How much harm? If we were to put a dollar figure to it, how much is it? And that's a question that's very difficult for them to answer without hurting their case. But that's the gist of our argument, and that's why in arbitration, your tone usually changes. Next, I'm gonna be talking about some real-world cases from our own experience in arbitration and what that looks like. Now, I also want you guys to keep in mind that arbitration with Amazon, it's completely confidential, so we're very limited to the information and the facts that we could share. So most of it will be general, but I think it'll give you guys a good example and good idea of what you're up against and what the results can be. Currently, we've got about half a dozen cases pending right now with Amazon in arbitration. And what I want to talk about are two recent ones where either inventory was being held plus funds or just funds. And one of them, our client was a wholesaler of electronics. Again, I'm not going to provide too much detail because there is a confidentiality clause. And they had over $300,000 in funds and inventory that Amazon was holding. And within, I want to say 6 or 7 months, we were able to get those funds and inventory released. We did reach a settlement with Amazon. And this is a client that had tried to DIY their POAs and appeals. That didn't work. They came to us. We tried synthetic arbitration. And while that wasn't successful, it gave us a good idea of what Amazon's position is and what facts do they have. Armed with that, we started arbitration, and then within half a year or so, we were able to get to that settlement. The next case is a client that had about 1.2 million in inventory and funds that Amazon was holding. And this is a client that had hired someone else to do the POAs and the appeals. They were unsuccessful. And again, we took this case to synthetic arbitration. And while that wasn't successful, that gave us the grounds and the arguments to proceed to arbitration. And within, I want to say 8 or 9 months, this case was settled and we were able to reach a settlement and a resolution with Amazon, and our client ecstatic back to selling on other platforms and on Amazon. So these are the type of cases that we encounter with arbitration. And with arbitration, if there's funds being held, then great resolution to go to arbitration. Again, it's got to be over $150,000. Otherwise, it doesn't make sense. If there's inventory being held, then there is a great case out of Arizona federal court called Schaefer v. Amazon. And that's a case we use all the time, and arbitrators seem to really like, and we get favorable results with that. So those are the type of cases that you'll see if you're going to Amazon. But again, you do have rights. Just because the BSA states that they could hold your money indefinitely doesn't mean that they really can. Just know that you have rights, and if you have any questions or if you'd want us to conduct a assessment to determine whether your case would be a great fit for arbitration, then let us know. Again, 95% of the cases that go to arbitration reach a settlement. So if you've tried all the other options and are looking for arbitration, then give us a call and schedule a consultation.